Well, welcome, everybody. I am your host, Daniel. I want to say this. When we get, excuse me, as I noticed that we are getting new subscribers every once in a while, you know what? That just makes it that I want to do this more and more. Seeing this channel grow on its own, and getting a couple new subscribers every once in a while, makes me want to keep going because I was going to quit because the channel had a bad reputation because some actions of other people. Now I just overlook it and I moved on. And I found my thing with the quartz. Yes, everybody is welcome here. As long as you, the main rule is if you want to be a part of this channel, you have to have respect. You have to have respect for me and have respect for the other people in the chat. That's all I ask. Just have respect. If you can't do that, you're going to be disrespectful and bring drama, I'm going to ban you. Plain and simple as that. I've learned my lesson the first time, and somebody said to me in Spawn Troopers chat that I've taken back this channel. Yes, I probably won't unban those people, but that's up to them. If they want to get unbanned and want to be a useful part of this community, then they need to email me. The email address is on the homepage of the channel. Just send me an email and we'll see what we can do. So today is Judge Alexandra Manning, and I believe that's Fulton County, Georgia, where she can be tough when she wants to be. Well, let's go ahead and get this started. You know, I don't want to come in here and listen to me talk all day long. Oh, I will be watching what I'm presenting to you. I'm not going to be watching chat. I have to watch what I'm doing because ads with music, if I don't catch it, we'll get the channel struck. So I need to watch that and take care of that. I'm not being antisocial. I'm just trying to keep the channel from getting struck for copyright, which I don't think is right. But let's get started with this. So share screen. Come back here and make this bigger. I want to make it bigger. Okay. And I'm going to mute my mic, but I'm here.
Yeah, okay.
Oh, they have it reversed? Okay.
So it's Wimbishi Kapuma.
So your name is, like, your last name is Kapuma then?
My last name is Kapuma.
Okay, we'll make sure I didn't want to destroy it, too bad with my accent. So I guess they need to know that because they have it reversed.
Yes, and because of that, it's an invalid contract.
Well,
Because
not necessarily, that's just a typo, but.
Yeah, but according to this.
There are hardworking people.
We're just kind of getting started here, okay? So I'm just trying to pronounce your name right. That's basically all that is, okay? All right, so this is number 122 CP 214772. Here it's Kapuma Wimbishi, but it's actually Wimbishi Kapuma. So I think they could probably modify that at the jail. I guess y'all want to take care of that. Okay, so we got 285 days without indictment. He had a Ferretta hearing and he's representing himself. So it's aggravated battery, willful obstruction of the law enforcement officer with a felony. Officer, if you could raise your right hand for me. You swear or affirm testimony you're about to give is the truth, whole truth, nothing but the truth.
Yes, ma'am.
All right. If you state and spell your name into the microphone for the court reporter, please.
Yes, ma'am. My name is Patrick Marsh. First name is spelled Patrick. Last name is spelled Marsh, Marsch.
Okay, Officer Marsh.
Okay, so 1 second. So, sir, what this is a preliminary here. Okay, it's just to establish that there's probable cause. So the DA is going to ask some questions, and then you get to ask follow-up questions. Okay, all right. So go ahead, Ms. Fields. And this is Ms. Kelly Fields. She's one of the assistant district attorneys. Go ahead, Ms. Fields.
Thank you, Judge. Officer Marsh, can you tell us, you already told us your name, but can you tell us where you work and what your title is?
Sure. I work for the City of Atlanta Police Department, and my title is rank as an officer.
Okay, and are you post-certified?
Yes, ma'am, I am.
Were you post-certified on the date in question? On December the 15th of last year?
Yes, ma'am, I was.
And can you tell us what happened on that day?
Sure.
Regarding Mr. Kapuma.
Sure. So on that day, I was dispatched to a call at 1776 Peachtree Street. There was a fight going on that apparently was going on the 4th floor at the clubhouse. We had received several calls as well, arriving on scene from a passerby saying that there might be a weapon involved. So I immediately called for backup. Officer Jones and Officer Easton arrived on scene to assist me. We go up to the 4th floor. We go to the right where the clubhouse was, and we found a white male victim named Keith Johnson that had a gash to his forehead. We had asked him what had happened, and he said that he had been knocked out by the defendant.
When you say knocked out, can you tell us what that means?
Sure. So apparently the defendant said that they had noticed, the victim had noticed the defendant acting in a strange manner. And when he went to put his hand on his shoulder to ask if everything was okay, he advised that the defendant hit his upper right eye with a closed fist, causing him to go to the floor and was unconscious.
Okay.
During that time.
So he was unconscious?
He was unconscious, but he was not unconscious when we arrived on scene. But
you were gaining consciousness?
Yes, ma'am.
Okay, now you said that this happened at what address?
1776 Peachtree Street.
Is that in Fulton County?
Yes, ma'am, it is.
And can you identify the defendant and describe what he's wearing and where he is in relation to you?
You can stand if you need to.
Oh, I can see it on the screen here, ma'am.
Yeah, that's okay.
Thank you very much. Yes, I can see the defendant. He is wearing a blue Fulton County uniform with a white shirt under it.
Okay. Let the record reflect that the witness has correctly identified the defendant.
All right, noted.
So we talked about that that Mr. Kapuma rendered this man, Mr. Hugh, unconscious. And is that the basis of the aggravated battery?
Yes, ma'am. So under the code section of 16-524, the elements of the crime for aggravated battery indicate that you render a limb unconscious. And so with the brain being a member of the body, we decided to go ahead and move forward with the aggravated battery because the brain was rendered useless during that time.
During the time that you was unconscious?
Yes, ma'am.
Okay, and did EMS arrive?
I'm sorry?
Did EMS arrive?
Yes, ma'am. Mhm.
And what happened with that?
I'm sorry?
What happened with, excuse me, I was talking
Okay,
about,
all right.
what happened with that?
So during the incident of while we were trying to get the defendant into custody, he was resisting myself and numerous officers. So one of the officers on scene had to deploy a City of Atlanta issued taser in order to try and get him into custody. And during that time, that's why we called EMS to go ahead and have them remove the prongs as well as go ahead and check his vitals because he did appear to be acting in some type of irregulated manner, whether it could be on, just having a mental breakdown or something of some nature, but he clearly needed some medical attention, which is why we go ahead and called EMS as well.
Was EMS called for Mr. Hugh?
Yes.
Okay, did he allow them to treat him?
He did not need EMS. When we got there, we asked him, he said that he did not need it. Some of the witnesses and the friends who were at the event were tending to the victim.
Now, with the charge of willful obstruction, was there any violence or offering of violence or just resistance?
There was no offering of violence. There was just actively resisting when giving verbal commands.
Okay.
Why is filing
And you said that Mr. Hugh Johnson was concerned about how Mr. Kapuma was acting?
Yes, so
Can you describe how he was acting and what you were told?
yes. So what I was told by the victim is that at some point this was a company event that was going on. And during the course of the event, at some point, the defendant had according to Mr. Johnson, had put his AirPods into his ears, and he started being very incoherent, saying a whole bunch of stuff that Mr. Johnson didn't understand. And according to him and several other people at this event, they had never seen the defendant act in this manner before. Mm-hmm. And so when Mr. Johnson went to put his hand on the defendant's shoulder, that's when the defendant acted out.
That's when the altercation happened?
Mm-hmm. Yes, ma'am.
Okay. Do you have any other statements you'd like to make to the court regarding these two charges pertinent to this case?
That's pertinent to this case, no.
Okay. So I have for right now, it's your witness, Mr. Kapuma.
Mr. Kapuma.
Okay, thank you, Your Honor. I have a question, right? Because according to this warrant, first of all, it shows here that he was called for a fight.
Okay, step back. What questions do you have for the officer?
Yes, that's who I'm asking, because I can't see him, so.
Oh, okay.
You can't see him on your.
Okay, so he was called in for a fight, right? So according to this statement, Keith Johnson put his hand first on me. Then I reacted to that with a punch. It doesn't show how hard he pushed my shoulder. It was in a hostile situation because I was at a party.
Okay, so stand by. What is your question?
So
who, what, where, why, when?
So in that situation, who was the aggressor in that situation? Because he put his hands
Hold on,
first on me.
Just ask a question.
Mhm.
So, okay, so based on when we spoke to the witness, I had the witness actually show me how he placed his hand on the defendant. And Mr. Johnson said he basically just placed his hand in a almost caring way, just a concerning way on his shoulder to see if everything was okay. And that's when the defendant acted out and hit the victim.
Okay, next question.
So is there a written signed statement from the witness about that incident to describe what you're saying so that they sworn like a
Hold
sworn,
on, hold on.
a sworn affidavit?
Who, what,
I
where,
said-
why,
I'm
when?
gonna have to object, compound question, can we?
All right,
Kind
so
of-
you ask a question like this. Do you have a written statement from the victim?
Do I have written a statement? No. Do I have it on body camera? Yes.
Okay, next question.
So there's body camera for the entire event from all 5 officers of what happened.
Yes, so my body camera was activated from the time I arrived into the parking deck before I made contact with anybody up until the very end of the incident as well. So there is a full body camera footage from start to finish, including a body camera footage from each of the officers during the interaction as well.
Okay, so from my recollection, right?
Whoa. No. If you want to say something, you have to ask him a question. So she asked him questions, so you ask follow-up questions to what she asked.
Okay. So based on the body cam video that you're saying, does it show that I was tased until I passed out or died and then had to be resuscitated?
So the body camera footage from Mr. Jones, I would appear because Mr. Jones is the one who tased the defendant, but the defendant at no point in time lost any consciousness or at any point in time had to be resuscitated by Grady.
Okay, next question.
So this, I understand. So when will I be able to see the body cam? Because I haven't had a chance to look at it, see what exactly happened on that event.
Well, all of that gets turned over at discovery, but allegedly you were there. So what's your next question for him?
According to the law, which I'm new to, did I give consent to be arrested? Because according to the
Judge, counsel, or I don't know if I should call him counsel, but
That's actually,
he's been testifying, and so we object to testify.
so did you give consent to be arrested? Did he give you his consent to be arrested?
Your Honor, he did not consent to get arrested, but based on the elements of the crime, we had enough probable cause to make the arrest.
Okay, next question.
because based on my understanding,
No. Next question. If you want to say something later, you can, but what's your next question for him?
okay, so in terms of the resisting arrest, is it not my right not to resist if there's no jurisdiction over me?
Stand by.
You said stand up?
No, I told him to stand by. I didn't know if you had an
Oh.
objection.
Yes, I have a judge, I understand you're giving him leeway and I understand the reason for that. However, counsel has been not asking direct questions on cross and he has been testifying numerous times. So we just have an overall objection to that testifying that's been happening from pretty much from the start of this questioning. So we ask that he ask direct questions, not have this kind of commentary in addition to his questions.
So what you're asking is him to draw a legal conclusion. So
Yes.
what's your next question?
Are you researching dental implants?
What's your next question for him?
Because for me, it's mainly about consent and
Okay,
jurisdiction.
hold on.
Mhm.
But that's argument. But what question do you have for him?
I don't have any questions for him.
All right,
Okay.
anything else with the officer?
I do have some redirect.
Okay, go ahead.
So officer, I know I was calling this the victim Hugh, that was my mistake. I meant to say the correct, and the correct victim's name is Keith Johnson, is that correct?
Yes, ma'am.
And Mr. Johnson was hit by Mr. Kapuma,
Yes, ma'am.
okay, and That's all I have.
Thank you, ma'am.
All right. Any follow-up based on those questions that she asked?
Basically, not really.
Okay. Thank you,
Okay.
officer. Stay safe
Thank
out
you.
there.
Thank you very much, Your Honor.
Have a
Stay
good
safe as
day.
well.
All right. Go ahead with the argument. Let's hear from the state.
So Judge, I believe that we have met our burdens for our probable cause for the first charge, which is aggravated battery. The defendant did render Mr. Keith Johnson's brain useless by, rendering him unconscious for a period of time where he did, fortunately regain consciousness, but he was rendered unconscious for a little while after he was struck by Mr. Kapuma. And as far as the willful obstruction, we understand there was no violence or offering of violence against, the officers and Mr. Marsh and other officers at the party. So we suggest that should be a misdemeanor and not a felony. But other than that, we think there's probable cause for both charges as just stated by myself and the state.
All right. Do you want to respond? Now, this is where you give argument. So now is your chance to give argument.
Okay, so first of all, based on just this warrant, my name is spelled in capital letters. It's in reverse. From my understanding of law, that's the name of a strawman or a corporation. So that does not apply to me because it says the accused is capitalized. That's a corporation, and a strawman, which has no bearing to me. And in this matter, I do not give consent or agree to represent my strawman in this case because I'm a sovereign being. I'm an internationally protected person. But at the same time, from my understanding of the constitutional law, which is the law of the land, I have to give informed consent or sign a contract in order to be judged or in order for the case to move forward in this regard. Because according to the Fifth Amendment, one of the things is before I can be arrested or detained, I have to be indicted. I have not been indicted. One, I did not give consent to be arrested or to be tried under this jurisdiction because I operate under common law. That's my jurisdiction, common law, God's law, and natural law. I do not consent to be tried by the Admiralty law system, which is evident by the gold fringe on the flag and the eagle at the top, which shows this is a maritime law, which is commercial law. And as a sovereign being, I report to God. God is my judge. As it relates to how I interact with other humans, it's only by common law, which is when I injure a human being, and that's also dealt with in the common law court. And based on my international status, because I am a king where I come from, an internationally protected person. So according to Executive Order 143107, which is human rights, this is a violation of human rights. From my understanding of the law and my rights, my unalienable rights, if I have not given consent to be tried or to be held or to be detained by or given jurisdiction authority to the officer, and they arrest me, that's a kidnapping, and I'm being held hostage right now. Because according to the Constitution, I have to be indicted before I can be detained. That's according to the Fifth Amendment rights. And the Constitution, from what I understand, is still the law of the land. Because according to the Supremacy Clause, every case, if I can cite one case, which is the Madison versus Marbury, every case in that situation, which cited that case as into the legality of the constitution or unconstitutionality of any situation, was overturned by the Supreme Court. So in this situation, yes, I did react to Keith Johnson putting his hands on me. Though the witness may have said something, they might have been friends with Keith Johnson. I reacted to a situation. For every action, there's an opposite and equal reaction. He touched me first. I reacted. When the officers came to arrest me, I didn't do anything wrong but defend myself. I've been charged with willful obstruction. According to the Constitution, according to my unalienable rights, according to my human rights, I've got the right to defend myself. If I put up on anyone over here and just touched you on your shoulder without even asking for your consent, some people will tase me, the officer will shoot me. But if the same thing happens to me, he touched me first, I reacted off of that. That's self-defense.
Okay, anything else?
Taxes.
All right, so I'll find probable cause on the aggravated battery, and then the misdemeanor, the willful obstruction will be reduced to a misdemeanor. And we'll go ahead and address bond. Let's see, because right now, bond, let's see. Right now, as of June 27th, there is a $30,000 good bond.
The defendant has 3 cycles. The defendant's last arrest was May the 9th, 2021 in Dunwoody, Georgia, for Terroristic Threats Act and possession of a firearm during commission of a felony and criminal attempt to commit a felony. There was no disposition for that arrest, and there are no convictions listed in the GCIC. Nothing in addition, Your Honor.
All right, go ahead with your bond argument, sir.
First of all, it was just a punch, and I don't see how it can be a felony. And if it was pretty much a misdemeanor at best, because one, it was self-defense, misdemeanor at best, the maximum is 1 year, and I've already done 10 months in jail pretty much for one punch in self-defense, in defense of myself. At the same time, I feel like I have already done the time for this.
Okay, anything else? All right, what says the state?
Judge, the state is inclined to keep the bond as is because the severity of the injury that took place. Yes, Mr. Keith Johnson, he was rendered unconscious. The punch that, counsel was trying to minimize was very severe. The punch took him out. So because of that, and then him resisting arrest, we do believe that the $30,000 bond is sufficient.
All right, so it'll be no further contact with Keith Johnson. Stay away from 1777 Peachtree Street Northeast. You're gonna have no drugs unless prescribed, no alcohol, no weapons. It's going off my bond order of 627. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. Are you still gonna live in Roswell, sir?
Sandy Springs.
Sandy Springs, okay. All right, so just supply a good address to the jail upon release. So 15,000 count 1 and count 2 is reduced to misdemeanor, so that'll be 5,000. So $20,000 good bond. Best of luck to you, sir.
I have no.
So this is an update to a bond modification that we ran back in June. This is Sade. I have no idea how to pronounce her last name. She is the ex-girlfriend of Neo, who in the original clip I mistakenly called a rapper. I apologize sincerely.
Bagnery's got cruelty in the first, cruelty in the third, and battery.
Correct, Judge.
Well,
Judge, I did not represent her at the first appearance. I got brought on afterwards, but I'll be quick and to the point. Judge, apparently one of the victims in the case, as listed on the bond orders, whom my client does not know, but more importantly, the second victim, Lawrence Gunn, is her son. According to the bond conditions, she's not supposed to have any contact and her son. The only problem is Mr. Gunn is her son, whom she takes care of. So again, Judge, I was not there at the first appearance, but it's kind of hard for her not to have contact with her son since she's the primary caretaker. Number two, Judge, she's 36 years old. She has no criminal history. She has 4 kids. One's a 2-month-old, which I believe she's holding there. Another one's 4. The other one's 15 years old. The other one is 16. Judge, I think it's been about 90 days since the date of arrest, give or take a day in either direction. But I was inquiring as to, one, if she can have contact with her son, because I think that might have been an error to have no contact with her own son. And then 2, if the ankle monitor can be removed. She has no prior criminal history, no prior FTAs. She lives outside of the county now, I believe in Suwannee. So she is local. Again, she's not a flight risk. I don't know why that was added on, but it just seems kind of odd considering she's a local individual with no prior criminal history, no prior FTAs.
So hold on, so
She doesn't, apparently, and her son had it out. Her son was being bullied.
at the bus stop.
She went to go ahead and defend her son because her son was being jumped, is my understanding. And then at that point, she went ahead and intervened. Is not her son. She does not and is. However, is her son, and part of the bond conditions was that she was supposed to have no contact with him, with her own son, which.
So this says that allegedly hit him in the back of the head and pepper sprayed him into his eyes, nose, and mouth. But she's only had this ankle monitor on for how long? Since
About
March?
90 days, Judge.
All right, Ms. Patton?
Yeah, no FTAs, Judge. I mean, she's
I
not a
would,
flight risk.
I'm sorry, I didn't mean to cut you off.
Yeah, I know this
Oh,
isn't
no,
one
that's
that
okay.
I did, so I mean, I can't speak if it was a mistake or.
I would object to removing the ankle monitor. However, I did take a look at the warrant in terms of contact with her son. It doesn't seem like she's had any issues with her son. So just so no long as there's, no violent contact with her son, not that I'm alleging that she's done that in the past, I just would have that as a condition. But based upon what's happened with the pepper spray in the eyes and choking and striking in the back of the head, I would object to removing the ankle monitor.
All right,
Judge,
so-
I have to beg to differ. For the purpose of an ankle monitor, she usually go to track somebody's movement. And she does not live anywhere close to the alleged incident anymore. She's over in Suwannee. My understanding is that this happened somewhere in Fulton County. But if she had FTAs or something of that sort, Judge, I would completely understand. And I would always have to agree with the state. But in this situation, there's no FTA. She's got no prior criminal history. She's been doing well for the past 90 days. Furthermore, she works as a bartender and a host event consultant and does host eventing or event hosting. Sorry if I got it backwards. So the ankle monitor kind of prohibits her from doing her job because no one really wants a bartender that's got an ankle monitor just bulging out. But again, if I had heard something as to an FTA or prior criminal history, I would completely agree and understand. However, I think that's far from the issue here.
Well, I tell you what, I'm not going to make her wear it a year, but I will remove as far as no contact. I mean, like I said, I don't know. Typically, if I put they can't have contact with the child, it's like if there's a juvenile court case pending and I'll let juvenile court order, control whoever does that. So if you come back in a few months and there's absolutely no violations, I'll be glad to take it off. And, let's see, what's this?
All right.
Back in September, we'll talk about removing it then.
Your Honor, if I may, you could switch it to a teletrax monitor if she's worried about it being in place at work. I do understand that might be an issue. However, like I said, it is to track what her movements are and to ensure that there is no contact. But a teletrax monitor might be easier if she's working to pass off. Is just it looks more like a Apple Watch.
The watch, yeah. Ms. Lewis, did they work out the issues with that?
Unfortunately, Judge, same update as last week when you asked.
Yeah, see, they haven't worked out the issues with that. So unless she wants to pay for it, because there's contract issues, whether the contract's going to cover that.
Yeah, it's beyond the pale of what we can even do or determine, Judge. We can't move the needle on any of this. This is kind of above us.
Well, I think that right there was sticking his head in.
That's the sound of an American.
just shoot me the order, Mr. Arca. We'll sign it and get it back to you. And like I said, just put it back on, come back 3 weeks and we'll talk about it.
Understood, Judge. Thank you so much for your time.
All right, thank you.
Judge, you said 3 weeks or 3
I meant
months?
3 months. 3 months, sorry.
That's what I figured you meant.
Yeah, sorry. All
I
right.
figured 3 weeks would be too soon.
Yeah, but just send that to me to remove the order. We'll get that signed off on.
Thank you, Judge. And who should I send the order to? You directly or to your chambers?
Sure, you can send it to me directly or Miss Robinson to the, what's the email? Is it Orca?
He should have the email from where he got the notice for today's hearing from me.
Oh, yeah, just send it there. Yeah, she'll get it to me, and I'm pretty good about signing them as just quick as I get them.
Thank you, Judge. I appreciate it and have a great night.
All right, thank you. You too. Thank you, ma'am. Best of luck to you.
It is now September, so they are back in court asking for the ankle monitor to be removed again.
All right, Sade, was it by your niece? 23.
Yes, Judge Manning. Good to see you, Alex Arca.
Good to see you. 23 CP 217236. Cruelty in the first, cruelty in the third, and battery. Bostic, preach. Rah.
I love that.
Nothing on Mr. The defendant, Judge, been out 3/29/23.
All right, go ahead, Mr. Arca.
Judge, I'll be quick. So last time I was before you was about close to 90 days ago now. I don't know if you recall this situation. My client was trying to protect her son and daughter from being beat up. There was a ankle monitor put on, and then her to have no contact with her son, which was an error. You went ahead and corrected it. You said come back in 90 days. If she's had no issues, we'll go ahead and take off the ankle monitor. Now, in full transparency, Judge, my client is a celebrity. She, I believe she can tell you what show she was on.
I don't know. She hasn't turned her camera on like she should.
Sade, you need to turn on your camera if you can. I know we've been on here a while. There we go. The pretty young lady on the left, Judge, that's her. So, Judge, she's a celebrity. This case has gotten some attention via the media, etc. However, I do have to make a point. She has had no contact with the victim or the victim's children. So she's been compliant with that. In fact, they now go to a different school. We're just here 90 days later to go ahead and ask that the ankle monitor or Talatrix monitor be removed. As you said at the last hearing 90 days ago, you said, hey, 90 days, she's had no problem, come before you again. Here we are.
All right. Mr. Scott?
It's actually 88 Jordan.
I have no idea who she is. Sorry, ma'am. I'm no idea who you are.
It's actually 88 Jordan on behalf of the state for this case, Your Honor. Good evening.
All right.
Your Honor, the state would oppose the motion to modify the bond conditions. I will make my argument as succinct as possible. I also do have an impact statement, Your Honor, from whom is the mother of the victim child in this case. Your Honor, essentially, as Attorney Arca was saying, the defendant is a high-profile individual. There were issues that came about as of September 11th. The defendant did post a picture of her ankle monitor in regards to this case. She also posted a few pictures and videos of children involved in a fight in this particular case. She also posted a direct message which highlights the victim's social media, or at least that she purported that this was the victim's social media. Your Honor, just to be as succinct as possible, we believe that the defendant here, there is a risk that she is using her platform to circumvent her bond conditions, to have indirect contact with the victim and the victim's family in this case. Your Honor, specifically, these particular posts were picked up by a large media blog Instagram profile called Shade Room. They have over 275 million followers. The particular post in which the defendant made was reposted by this blog site and had over at least 156,000 people view that particular post, Your Honor. We are concerned. We completely understand that the defendant is a mother, but we also, as a state, have to present that the victim has a mother as well. These are all children that are involved in these videos. I don't want to specifically make an argument in regards to the case, but if the defendant has an issue with the children, she should go to the police and not post these videos on social media. Your Honor, as I will say in the impact statement that's provided by the victim's mother, this particular post on September 11th has affected her child. The child has been sent screenshots of the September 11th post that made the shade room. So, Your Honor, we would say that the defendant, and albeit extremely recently, this was only a week ago, we are concerned that she is not abiding by her bond conditions. And we would ask that Your Honor deny the motion to modify her bond in removing the ankle monitor. And I can provide that impact statement now, Your Honor, if you would like.
Sure, go ahead.
Thank you. To whom it may concern, per OCGA 17-71, as the mother of the assaulted victim, I understand that I have the right to address the court in relation to the defendant's request for conditional changes of her bond release. I'm pleading with all parties involved to heavily consider my sentiments regarding the defendant's request prior to making a ruling today. I'm requesting that the defendant's bond be revoked and she be arrested due to the violation of the original bond agreement. I'm also asking that she be granted another bond or be allowed to remain free on her current bond, but that the ankle monitor remain in place and a gag order be added as conditions to her bond. The defendant is utilizing her celebrity and social media platform to incite violence against my son and other minors, which could potentially escalate what started as mutual combat initiated by her son into another assault or worse. Lethal consequences as a result of retaliation by her followers. On September 11th, 2023, at approximately 2 p.m., the defendant posted a video and other content with my son's image and alleged social media profile, as well as other minors, regarding the open legal matter of her and her minor son attacking my son at the bus stop. The intent, I'm assuming, was to control the narrative and minimize embarrassment of the pending child cruelty charges because a gossip site posted details of her arrest. They reached out to me for comment and I declined with the intent to protect all minors involved. The content has now leaked to several very popular social media gossip sites, whereas of 2:30 p.m. on September 11th, one site had a minimum of 60,000 followers engaged with the post and at least 1,300 people encouraging her heinous act against my son, making direct statements that he should have been murdered and put on a t-shirt. Less than 12 hours later on this same site, 160,000 interactions were recorded with other 15,000 individuals posting comments. As of 10 a.m. today, there's over 200,000 interactions and 25,000 comments supporting, encouraging, and inciting violence against the minor and anyone associated with egregious comments such as, please post the kids and parents' info so we can help with the bullying situation. What's the bully's at name? We're trying to do something. Tell them to pop back out. Richie One Rich does beautiful t-shirts. Their family would have been ordering a few. I hope when she pops one of them, y'all don't get in the comments crying and defending them. Swiss cheese all them folks. Girl, do you need us to pull up or something? That's just a few. I've known of the defendant's social status and celebrity affiliations since the first of 3 altercations between both minors on February 24th. I've never once used that information to attack or tarnish her character because I don't want to compromise the safety of either minor. I've maintained the position of protecting both minors and attempting to resolve the conflict in a civil and mature manner before, during, and after involving authorities and pressing charges against her. In addition to her involvement, the threat of shooting up my home, individuals driving around my neighborhood in ski masks asking where I live, and her son recording and posting via social media threatening to kill my son is the exact reason I exercise the right of a temporary protective order. I am in fear of my son's safety as well as my own, even more so now that our names have been leaked via social media and individuals are requesting my profile be tagged for others to intimidate and attack me and my son and other minors based on her false, exaggerated perception of events. Her social media engagement is allowing her to further perpetuate a hostile situation by twisting the narrative to garner support on a private matter. While I am aware that the court of public opinion will not be prevalent in the court of law, I'm appalled and disappointed that she is using her platform to encourage fans and advocate violence against minors and others. Her actions put both of our children at risk of being hurt or even worse, murdered over what started as a school fight between peers. And I'll sum the rest of it up, Your Honor. I do thank you for your time. My son has received several screenshots of the September 11th social media post from his peers, forcing him to relive this horrific event. We are both experiencing anxiety and stress because of it. He also fears for his safety. It's affecting his ability to focus at school. There's still fear to ride the bus to or from school, even though the co-defendant has been expelled from all Fulton County school properties and events. We both have trouble sleeping. He's afraid to hang out with friends. I even had to hire additional security for his birthday party this past Saturday because of her September 11th post, for fear of someone attempting to attack him while he celebrated. I would like to ensure that she's held accountable for her bond order violation. Her whereabouts are monitored continuously, and that our freedom of speech regarding this matter is revoked until the conviction has been issued and the case has been finalized. Thank you for your time, Your Honor. That does conclude the state's presentation.
Judge, can I go ahead and make a quick statement?
Sure, you can go ahead and respond.
Yeah, Judge. So number one, the client had not, the defendant had, not the defendant, sorry, the victim had an opportunity to be present, did not be present. Number two, I think it's unfair for Sade, because of her status, because of being a celebrity, to not be able to go ahead and post or comment when she's sent me screenshots of news anchors, social media, websites, and things of the such, to go ahead and ask her to comment. In fact, she's sent me screenshots of that, and they're all asking her to go ahead and present a comment. As far as the posts and the blogs, all she's done is protect her character, say that she protects her kids. She did not show the face of the kids at all or say their name. All she did was tell her story. This is a criminal court. This is not talking about, we're not here to talk about the First Amendment or freedom of speech. I know the victim went on, but you directed Miss Sade Baggernice to go ahead and stay away from this individual. They've had no contact. She's taken her children out of the school so that they don't have any more problems. Now, if social media sites are reaching out to a celebrity asking for comment and commentary, I don't think that this is the appropriate court to go ahead and put a gag order in place.
Never ever sue the other driver after a car accident.
And Judge, you might have your own opinion, but I think I'm accurate when I say that the criminal court can't go ahead and sanction her for being a celebrity, and more importantly, for social media sites to reach out to her to ask her for her story. In fact, that's her right to go ahead and talk about it. However, she's not saying, hey, the victim lives at X address, they go to X school, this is where you can find them. She's done nothing of that sort. She came back 90 days later. She hasn't reached out to this woman. She hasn't touched her. She hasn't touched her kids. She hasn't said where they go to school. In fact, you've got everybody reaching out to Sade asking her, hey, can we go ahead and talk? Can you do a news story? She can't control whether or not 60,000 or 1 million viewers reach out to the website, and if the public's talking, Judge, the public will talk. You've been in many news stories before. You know, you're one of my favorite judges, but you know how that goes, Judge. But at the end of the day, I think the question is, did Ms. Baggernice go ahead and violate anything? She hasn't. She hasn't reached out to her. She hasn't reached out to her kids. She, in fact, hasn't said, hey, you can find them at X school, at X bus stop. She stayed away. She's done everything you've asked. And for that, I asked that you just go ahead and remove the ankle monitor. I mean, there's no issue with her. She's appeared in court when you've asked. The whole purpose of bond is, will they go ahead and appear in court when their time is called? She has. She's on at 7:15. This is obviously important to her. She's just merely protecting her character. We can't fault her for being a celebrity. She hasn't gone ahead and bashed the woman or the kids. You know what it's like to be on the media. Judge, I just asked that you go ahead and remove the monitor. I mean, at the end of the day, she's appearing every time she's supposed to. She's hired counsel. You know, I come to your court, and every time I've appeared with my clients. But I asked that you go ahead and remove, because at the end of the day, what has she done wrong? She's being asked by social media platforms to go ahead and comment. That's her business. She's a celebrity. I mean, you're a celebrity in a different ring of people, but at the end of the day, you don't see her violating by going near this person. You haven't heard anything in 90 days from this lady.
Like I said, I don't know who she is. No idea. Doesn't really matter, honestly, if she is to me. But if some of these things are getting, sorry, I went a little blurry there. If some of these things are making the parent of these other children get threats, that's nothing. That's beyond not cool.
Yeah, but Judge, at the end of the day, she has no control over that. I mean, she's got zero control.
If I may, Your Honor, respectfully, because I do respect Attorney Arca, it's exceeded by making a comment on the case and further posting pictures or screenshots or videos or whatever may have been posted. That exceeds it. That goes to a deep concern there for the state. I know that as adults, we may not view social media to be quite as important as children do, but these are all children that are involved in this particular case, where one of us may not be able to identify a child. I'm sure that a lot of these children who go to this particular school, they know the Shade Room. It's an extremely popular blog post. They can easily pick out which child is which in those videos. That is where it's exceeded. I'm not saying that the defendant does not have the right to say that I did not do these charges and I'm going to fight them in a court of law, but it is concerning for the state to look on a blog post and see potential videos of children being involved. And as I've said before, and I don't mean to repeat myself, if these were violent acts that the defendant has recordings of, the place for them is not an Instagram story or a blog site. It is, she should take that information to the police, because that's not doing anything but bringing more harm to children in this case.
Judge, again, she's done nothing wrong. She hasn't gone near the defendant, near the victim, near the victim's children. She has not provided an address to those people. She's a public figure. She's a celebrity in her circle, in her circuit. But the purpose of the ankle monitor is to go ahead and track her whereabouts.
Right. And here you go. I just Googled this, and I'm seeing some of this was posted 6, 7, 8 days ago. Why are you doing it right before you come to court?
You're on mute. You're on mute, Sade.
I don't want to hear you say a word, ma'am. I do not want to hear you say a word. But, and I know you, Mr. Arca, one thing you always say to your clients is, stop talking about what happened. Stop talking about it, because it's not helping you. Because when you post something and you use one word the wrong way, Mr. Jordan's going to say, no, here you said shall and should and did not, and all that stuff can get twisted. The only thing this is going to do, ma'am, is hurt your case.
The way you
Who cares that the media wants to know what happens? If you're not guilty, then you're not guilty. Who cares? In my position, when I'm on there, I can't say anything. And trust me, that's horrible when things are being said about me. But
I'm still here. Stop posting stuff. These are kids that are, man, these are kids that are involved. And if you haven't been watching, there are kids on here that are hurting other kids and committing serious crimes, allegedly. Let me do that, allegedly, because they have that presumption of innocence. But if you watch my bond hearings, if you watch the news, children are killing children. You are pouring gasoline on a fire. And if one of those children gets hurt, that is on you. Because of something you did, because you think you're a celebrity or whatever you do. I have no clue, but I don't care who you are. You have no right to pour gasoline on a fire that could maybe get some child hurt. Put it on the other foot. What if the non-celebrity mother did it to your child? You'd be up in arms. You would be beside yourself because somebody was posting something in the shade room or whatever it is and talking to the media. You would be beside yourself. You would have your high power lawyer write them a cease and desist letter and all kinds of other things. Put the shoe on the other foot. Act like you're a mother. Even if one kid picked on your kid, that's what happens. Let the system handle it, not you. If people are posting stuff that they want to pull up and do we need to go handle this? God, all you're doing is inciting people that think they know you and think they want to help you when you don't need help. The only person you need help from is your lawyer. I mean, the ankle monitor is not keeping her, it's keeping her away from them. But if it's obviously not posting her side of whatever, I mean.
Judge, if I may, I think,
Go ahead.
given the words you just stated, I think she's gotten the message clear. I would still kindly ask Judge that you go ahead and just allow her to remove it. I think Ms. Baggernice has now a clear understanding of your position and where you stand.
Well, but I do want to add that she stops posting stuff about these kids. I'm not interfering with her First Amendment right. You can say whatever, but stop posting stuff about these kids anywhere.
Understood, Judge, and I think she gets that loud and clear. Would you be inclined to at least allow her to remove the tallow trick, since it's really, I think it served its purpose. I think from what you see here today, just based off her facial expressions, I think she's heard you loud and clear, Judge, and I'll have a frank conversation with her as soon as I get off.
What is she doing?
She's crying.
All right. So, but just add that she's not to post anything else on social media about this. I'm not interfering with her First Amendment right. One post I want her to make, and I want Mr. Jordan to let us know if she makes it, is it to tell people to stay out of it. This will work itself out. Leave it alone. She's not wanting anybody to do anything. She's got you and she's got a good lawyer and you're going to handle this. And let the mother, if the other kid's a bully, let that mother handle it.
Understood,
Children
Judge.
don't need to get harmed over this. You could add that, she could take it off. And like I said, but I want to see something posted on wherever. Leave it alone.
Understood, Judge.
Leave these children alone.
Yes, Your Honor.
Am I clear, ma'am? Just give me a thumbs up. All right. Is that good with you, Mr. Jordan?
Yes, Your Honor.
When
Understood.
you make that, let me make sure that you can say whatever you want to about me, but I'm going to protect these kids. So make sure that hopefully Mr. Jordan will see it or show Mr. Arca the screenshot. Don't put it up there and then take it down. But you encourage people to leave anybody involved in this alone and let the court system handle it. Please, for the safety of everybody involved, because you're going to get some people hurt. And I don't care who you are.
Judge Manning, your assistant, what was her name again? So I can go ahead and send her the order after sending it to Mr. Jordan.
Gloria Robinson, you can send it to her.
Ms. Gloria Robinson.
Travoria,
Where you got the
same one that sent you the
invite
link.
from, where you got the link.
Oh,
from.
okay. Got it, Judge. Thank you so much. I appreciate that. Thank you, Ms.
Just-
Robinson.
Just so you know, I'm impressed with people like Pat Benatar, one of my favorites, but.
You gonna say preach off for me one more time before we go?
No.
All right,
Thank you.
I'm
Judge.
sure half the people on here have no idea who Pat Benatar is.
I do.
I'm
I'm a
not that
child of
old.
the 80s.
I do.
See, we do, Bostic.
All right, Judge. I'll get that over to Mr. Jordan before I send it over to you, Judge.
All right, y'all have a good one. Thank you. Good to see you.
Thank
Likewise,
you.
Judge.
My condolences.
In regards to Mr. Chase, multi-state offender, 5 in Tennessee, 2 in Alabama, 2 in Georgia. Open case 22 SC 182644, felony obstruction, terroristic threats, 2 counts, criminal trespass, assigned to Judge Carnicella. Nothing further.
You see, Mr. Chase.
This hotel. I have the video for the court's review if you want it. The St. Regis was kind enough to make me
Mr.
security video.
Kane, stop. Mr. Kane, are you driving? Mr. Kane, you're gonna have to pull over. I will not be responsible for you wrecking. Come back when you pulled over. I can't do this. Go ahead, Mr. Berger. Sorry. What is
This happened on the front door of the St. Regis Hotel.
right?
And there's ample video, surveillance video of it, as you would imagine. The video is certainly somewhat different than the account given by the complaining witnesses. But nonetheless, be that as it may, he has no record of any convictions. He's entitled to bond. He will be living in Nashville. As the video indicates, and I think as was indicated in the first appearance, Mr. Chase got the worst end of it. The video shows he's the one who got his face smashed in when all was said and done, and there's a big pool of blood here and from the lobby of the St. Regis as a result of it. But we just asked for a reasonable bond. Conditions of no contact with the witnesses is certainly acceptable to us. We have no reason for that. There's no reason for him to be here other than to see me. My office is not in Fulton County, so it's he can come across the river and see me whenever he would like. And we just asked for $25,000, and we'll be back to deal with these cases when the time is right.
Ms. Amjadi.
Thank you, Your Honor. On September 14th, the court denied bond on the basis that the defendant posed a danger to the victim and to the community. While it's true,
Is here, so go ahead. We'll hear from you if you'd like.
he is here and he would like to address the court, Your Honor. We have explained to him that at this point, the defendant is legally entitled to a bond. I would just like to note for the court that the defendant's criminal history spans 3 different states, Georgia, Alabama, and Tennessee. Let's see. Out of Georgia, Your Honor, there was a terroristic threats case and this aggravated assault case. While it may be true that the defendant sustained some injuries as a result of this incident, it's because he threatened somebody who was trained in hand-to-hand combat with a firearm. We would respectfully request that the court grant a bond no lower than $100,000 and house arrest in order to guarantee or provide some protective measures for the victim who is in fear for his safety. With that, Your Honor, may I please inquire?
Sure. It looks like it says here that allegedly, Mr. Berger, that he says, Mr. Chase says, I ain't the one, all it takes is 7 pounds of pressure. It's incorrect. It's 5.3 pounds of pressure on the, it's 6.2. So it's not quite 7
You want to take yourself off mute and raise your right hand? If you can hit that little microphone. There you go. You swear a firm testimony you're about to give is the truth, whole truth, nothing but the truth.
Yes, sir.
All right. Thank you for showing up. Mr. I'd like to say as far as bond, and if you're
Yes, sir.
fearful, if you
I
accept
understand. Your Honor, I'm extremely afraid for my life. And more so, I am terrified for the lives of my children. Mr. Chase has a history of coming after his victims. In Tennessee, the Tennessee law had to change because of David Chase.
The situation that caught everybody's attention was a domestic violence one. It started at 4 a.m. on June 8th of 2014, when a Nashville, Tennessee woman reported that she had been attacked by her boyfriend, David Chase. Metro police arrived at the location, and the woman indicated that she and Chase had recently broken up. When she returned to the residence to get her belongings, Chase pulled her out of the residence by her hair. When officers arrived, Chase refused to open the door and told them to go get a warrant. Less than 2 hours after the original call, officers returned with a warrant and arrested Chase, who remained uncooperative, according to the report. Less than 30 minutes later, he was processed, and a judicial commissioner, which is similar to a magistrate in Tennessee, ordered a 12-hour hold, meaning Chase was to be released right around 6:30 p.m. that evening, which is pretty standard in domestic violence cases across the country. Sort of a cooling off period to keep anything bad from happening. Around 9 a.m., just over 3 hours after his arrest, and 5 hours after the initial call to 911, Chase's attorney contacted a judge and asked for the hold to be lifted. You see, the judge and the attorney were personal friends. Good old boys. So the judge lifted the hold, and by 10:30 a.m., Chase had returned to his residence. The victim, believing she had 12 hours to collect her things, was still present at 10:30 when Chase returned to the residence. According to the police report, Chase choked the woman and told her, "You ruined my life. I'm going to kill you. I'm going to throw you out the balcony." The woman was somehow able to break free and ran to the neighbor's house, where she contacted law enforcement. Chase fled the scene. When police arrived, they found blood on the walls of the residence. Chase was arrested again for a second time within a 12-hour period and charged with aggravated assault by strangulation, interference with a 911 call, and vandalism. The interesting part is, he was released again without a 12-hour hold. When it was found out that Chase was released early, and that was the cause of the second domestic violence event, there was an outcry across the county and further, especially from domestic violence advocates. But even the Metro Police Chief, Steve Anderson, accused the judge of choosing the good old boy network over victims of domestic violence. He wrote a scathing letter to the presiding judge of the county, and many called for the judge's resignation. The only positive outcome of the ordeal was legislation that was passed, making the 12-hour hold or cooling off period mandatory, meaning a judge could no longer waive that. So all of that history was just to tell you, yeah, that victim's telling the truth. David Chase and his domestic violence history did change the Tennessee law. And now you know.
Because he had a domestic violence charge, which anyone can Google, and was released early and immediately came after that victim. Mr. Chase did everything he could to kill me in front of my wife, 4 other people. And if you look at the videotape, I never hurt this man. He was holding one of my wife's employees against her will in a car. And then when she escaped the car, he came after me and repeatedly tried to instigate me. And I still never went after this man. If anyone else besides me was there, they would have a bullet through their head because of David Chase. And again, Your Honor, I'm afraid for my life. But I know this man has a history of coming after the people that he'd hurt. And I finally bested him and stopped him. I know he's coming after me. I am terrified for my children's lives. And I would plead with the court. He's going to live with this family. His father is the 2nd largest land developer in the state of Tennessee. The $100,000 is nothing to their family. I would like to request that for my children's safety, my family's safety, because now he knows where my wife works. Now he knows my name. That you give him $1 million cash bond because it keep my children alive.
Both David and his father are very well connected in Nashville. Whether that plays a role in his treatment is up for debate. You see, when David was arrested the first and second time on June 8th of 2014 for the domestic violence related events, he was already out on bond, a $3,000 bond to be exact, for a February 2012 DUI charge. Prosecutors tried to revoke his bond several times, unsuccessfully, following that 2012 DUI arrest. The month after the arrest, he actually received a second DUI, but the charges were later dropped. Then in June of 2014 came the domestic violence arrests. Then finally, in early August, he had an alcohol violation that was detected on the ankle monitor that he was wearing. He had a hearing regarding this bond violation in late September. Prosecutors argued for his bond to be revoked. They also argued the same thing following the domestic violence arrests unsuccessfully. In this hearing, instead of revoking his bond, it was increased significantly from $3,000 to a whopping $9,000. He was also placed on house arrest and had to continue wearing the GPS and ankle monitor. So at this point, David Chase had charges of domestic assault, aggravated assault, vandalism over $1,000, interfering with a 911 call, 2 counts of DUI, which included 3 bond violations. At subsequent hearings for all of the cases, as well as the protective orders that were filed by both sides, Chase's ex-girlfriend testified that she thought he was going to kill her. Chase's side countered that she was the one stalking him, and Chase was the victim in this whole matter. And he had added pressure from the media, who was demonizing him. While the cases were pending, Chase stepped aside as the developer for a planned 240-room Virgin Music Hotel on Nashville's Music Row. That's a tongue twister. He also resigned as executive vice president for DF Chase Inc., the general contractor for the hotel project, which is his father's company. He said in a statement he needed to focus on the domestic violence cases. Exactly 1 year to the day following the domestic violence events, Chase filed a federal lawsuit against the Metro government and a dozen officers who were involved in his arrest. The 20-page complaint alleged officers violated his civil rights, failed to follow proper police procedure, used excessive force, committed assault and battery, and subjected him to false arrest and imprisonment. He claimed that his ex-girlfriend, the victim in the event, was friends with at least 2 of the officers involved, and that they may have participated for purposes to further agendas related to her. Chase later added District Attorney Glenn Funk and Assistant District Attorney General Katie Miller to the suit, alleging malicious prosecution. The state hired DA Funk's former law partner to represent him in Chase's case, as well as
At the center of it all says he was denied his legal rights. Investigative reporter Ben Hall has details tonight.
Well, Vicki, David Chase.
If we have 24-hour house arrest, then and precision tracking, location tracking, then I think we can ensure some safety to Mr. Yarbrough and his family.
And I did like Mr. Berger, this other case that he has here also happened at another hotel.
And the district attorney seeing fit to recommend to the court to plead to misdemeanor, and we've indicated we don't want to do that. We've seen the video in that case, and there's not a case there. And Judge, on this particular case, it's important to note, it was me who drove up to the St. Regis in a car and confronted Mr. Chase. Mr. Chase was sitting in a car with a service dog, and he came up, drove up to the St. Regis, jumped out of the car, and confronted Mr. Chase. We have no idea. Mr. Chase has never met him, doesn't know. The only interaction they've had in this case is the fact that Mr. came to the St. Regis to confront Mr. Chase, who was literally in front of the hotel with his service dog. He's on disability. He lives in Nashville. He was there to see me. Okay, his mom brought him down here to see me because he was having court with her the next day where we were asking for trial with Judge Carnesale. Okay, I don't know what's in Mr. Yarbrough's heart, and I have no reason to disbelieve him. But at some point, we have to kind of look at the facts of this case. The reason why Mr. Yarbrough is involved is because he drove up and came up on him. And I'm happy to show the court the video. I mean, it's the St. Regis. There's 15 different angles of this. You know, whatever, however it escalates, there's no audio. I don't know. That'll get sorted out in the case. But to try to make an example of him and to ask for bonds that, you know, because his family is wealthy while Mr. Chase is on disability is getting a little, I don't know how to describe it. You know, I'm not going to take up the court's time. It's 7:30. These are strangers on strangers. You know, we're happy to go away and not come back to Georgia or whatever the case may be. But he needs to get let out. He's entitled to a bond. It's the 91st day. If this was such a big, easy deal, I would imagine it would have been indicted already. But it's not.
Ms. Amjadi?
Yes, Your Honor.
You wanted 100, what did you want?
That the court grant a bond no lower than $100,000, Your Honor, and house arrest with precision monitoring.
No drugs unless prescribed, no alcohol, no weapons, no further contact. Stay away from 88 West Paces Ferry Road, is the Regis Hotel and any Regis hotels. No further contact with stay out of Fulton County, sir. Only come back to Fulton County for court to see your lawyers. Matter of fact, stay out of the state of Georgia unless you come into Fulton County for court.
And your client can come on up to the front. If you have a lawyer and they're not here yet, just let me know, okay? Because we can hold it for a little while. A couple people already know that your lawyers have conflicts. So we will chat. How about Amanda Clark Palmer and Richard Goodine?
Morning.
Sorry, I was calling you like a.
Okay.
All right. What do we have for Mr. Goodine?
Oh, he has no violations. He's been compliant.
All right.
Good to see you.
Good to see you, Ms. Clark Palmer. Y'all have a good day.
All right, thank you.
All right. Let's see. What about Charles Lester? Charles Lester.
Mr. Lester was released to PAD and the case is in judicial hold, but according to the notes in Odyssey, he's not had any violations.
Yeah, we've not been tracking him since 22 from another company. He's not tracking. We don't have a monitor for him.
So did he have an ankle monitor on or no?
No,
Are you sure?
he's not been tracking since 22. I can confirm, but as far as I see, he doesn't have it.
I'm sorry, Miss Feely, what did you say?
There were no notes in Odyssey.
All right, so
Going down your calendar.
Well, I mean, if they saying that he was never given it, there's never been an order for an ankle monitor? Or
I mean,
He was released in 22.
he had one then, so I don't,
why don't we just, there's not a whole lot, we need to investigate that. Just see what the status, he was released from custody. So he was supposed to have an ankle monitor, and this is before you guys got onto it. So that was under Halatrix, possibly.
I don't know, it was done by me. I don't know if that ankle monitor paid for by the county on my bond order.
All right, well, there's the court order for it. And,
And I'll check with Judge Lefferts too.
okay.
All right. All right, I've got Justin Baylor. Mr. Baylor. Come on up. Is that someone in your office, Ms. Feely?
It is not.
How about your lawyer? Do you know where your lawyer is? In a courtroom? Uh-huh. Was it okay. What does it say about his?
He's in compliance.
There you go. Good job. Thank you. Let's keep it up. All right. What about Macy Thrash?
Your Honor, can we turn the microphone on at the podium?
Oh, it's green.
It's green.
Oh, then it should be on. Tap it. Tap it. Yeah. So maybe pull it down a little bit. I think he was maybe standing too far away also. Yeah.
Possibly, yeah.
All right.
Thank you.
All right. Macy Thrash. Where's Mr. Melnick? Anybody know?
Nelson system.
Looks like he's already got a. Go ahead. I'm sorry.
Oh, yeah, I just, is there, does the court want an announcement from the state? If
Yes, go ahead.
obviously subject to good notice, Your Honor, the state requests bench warrant bond forfeiture.
All right. What is he? What's going on with his?
She's not tracking either. She's not tracked since the other company, 23.
All right. All right. Let's see. Keontae Guthridge. Keontae Guthridge. Miss Feely, that's your folks?
Yes. Now.
What do we got, ankle monitor?
The only thing he has on him is a dead battery from 10/7 to 10/8. October 7, October 8th.
What about at pretrial?
No new arrests. It's been on since 9/1/22.
Right, so, subject to good notice, Your Honor, state requests bench warrant bond forfeiture.
All right. Anything, Miss Feely?
He's been appearing for Judge Cox's calendars, and given that there's only one violation, we'd ask the court to just allow Judge Cox to continue handling it.
So, who's Mr. Melnick? Mr. Melnick, his client seems to think that if he updates the address in Odyssey, it gets updated with the ankle monitor company. All right, so yeah, I'll check that out and check with Judge Cox. What about Leonard Hodges? Is that from your office too, Miss Feely?
And she's new with us, so.
What about an ankle monitor company?
He has 2 violations for inclusion zone. He was tracked at a residential home and at a gas station on 10/10.
Boston.
No new arrests. Had it on since 6/25/22.
All right, Miss Feely.
Eric, he's been on this ankle monitor quite some time. We'd ask the court to consider removing it, given he's mostly in compliance.
All right, I'll reach out to Judge Cox and ask him. Looks like he's set for trial in January. I think. Yeah, January 7th. Does that sound right? All right, what says the state?
Your Honor, we'll leave it in your discretion in connection with this ankle monitor.
All right, Ms. Feely, I'll check with, I got a lot of emails to send Judge Cox, so send Judge Cox an email. Thank you, sir. Keep it charged. So we don't have Mr. Wright here yet, but Jamarius Rogers? What about Jamarius Rogers? How's his going?
He's doing fine. He did call our office there on 10/6, and he said he wasn't aware about the 24-hour house arrest. He was only told to charge his monitor.
So now you good?
Yes.
Okay, thank you, sir. Take care. All right, Matthew Chiselin?
That's my client. I haven't had contact with him in over a year. I was not expecting him. There's already, I believe, a bench warrant and a judicial hold status for the case in Judge Cox.
Judge Cox, what says the state? That was from 2023.
Subject to good notice and the circumstances by defense counsel, we would request a bench warrant, but there's already one out there in connection with this defendant.
I know there's a hold. Let me see if there's a warrant. I don't see the warrant, but if there's not the warrant, I'll do that. All right. Thank you, Ms. Rhonda.
Thank you.
Rodriguez Gunn. What do you got for Mr. Gunn there?
One quick second.
Bostic?
No new arrests. Had it on since 6/4/21.
It's good. I have nothing on his end as well.
All right. It looks like Ms. Feely, this is yours too, right?
He's got a final plea with Judge Williams coming up as well.
Yeah. Yeah, and so, yeah, you got a final plea November the 3rd. All right, sir, thank you so much. All right, let's see. What about Dathan Hardy?
We're skipping 10?
Excuse me. Yep, I did.
Okay.
But I'm sorry, no, I'll go back. Skip number 10.
Oh,
No, go ahead, yeah, Dathan Hardy, go ahead. Bostic, what do we got?
He's had it on since 12/12/21. He was in custody on an FTA on this case from 11/8/24 to 9/3/25. He's had 2 new arrests since being out in 21. Obstruction in 23 and a meth and obstruction in 24.
Hey, Commander.
I have one violation on 10/8. He was tracked at a Reflection Student Apartments. That's one thing I have for him.
He was tracked to who?
He was tracked at a apartment complex that's not his home. Reflection Student Apartments. That's the name of the apartment he was tracked at.
Reflections?
Student apartment.
But what was that for?
Personal.
Okay. Your Honor, to my knowledge, Mr. Hardy has he's applied to 16 different jobs and had at least 2 interviews, and that Reflections apartment complex is one of the places he was working, doing pressure washing. I received an email prior to this calendar about the inclusion violation, and that's when we had a phone call. And I let him know that anytime he has to leave the house for work, whether that be a job interview, an official schedule, he needs to let the ankle monitor company know in advance so they do not violate him for something that he is allowed to be doing. So going forward, he knows to call the ankle monitoring company as well as to let me know that he's got, XYZ job interview and or I'm going to this place at this time for this job.
Right. Also, if you change addresses, all that, and I would call them and email them. Thank you, okay? All right. Thank you, sir. All right.
All right.
Let's go back.
Or maybe we'd be excused?
Yes, ma'am.
Thank you.
All right. Back to number 10, Master Perry. Master Perry. Ms. Feely?
I have to, there weren't any notes obviously about any violation. I know it's assigned to Judge Krause.
Oh, we got Bostic.
He's had 1, 2, 3, 5 arrests, but they mostly for driving with a suspended license. Last one was 10/28/24 misdemeanor obstruction. He's been out since 8/31/22.
All right. Mr. Jenkins?
Well, if he certainly isn't here, so at this time, subject to good notice, state request bench warrant bond forfeiture, Your Honor.
All right. What about you? What about?
He's had 5 different dead batteries on different days.
What days?
9/15, 9/17, 9/19, 9/23, 9/30, and 10/8.
All right, subject good notice, then yeah, we'll do bench warrant. What about, let's see, next one. Deshaun Watson. Deshaun Watson. Is that y'all see, Miss Feely?
It is, and his also says that he's not, there's no note of honesty about any violations.
All right, what about an ankle monitor?
He's not been tracked since 22.
Where's this? What about Bostic?
No new arrests. Been out since 7/19/22.
Tracking since 92. Wow.
Mr. Jenkins?
Your Honor, that is state's request for bond forfeiture, bench warrant.
And I think,
Subject good notice, of course.
and with these that are not tracking, I don't think we have any information about whether that is the fault of Mr. Watson or not. So we'd ask the court to just let Judge Kraus handle it.
Well, I mean, he didn't show up today. Yeah, I mean, I'm gonna check with Judge Krause and see. All right, let's see, and make sure it showed up. Savion Blankley. What about an ankle monitor?
He only had a dead battery for 2 hours on 10/8, and that's the only thing we have for him.
Bostic?
No new arrests, had it on since 9/26/22.
Mr. Shard, anything?
Been pristine, pretty much on an ankle monitor, and he's done everything he's supposed to do. I think we're close to a resolution on this case, but otherwise I'd ask if he could be relieved of the ankle monitor.
Is this the 1024 case?
It is.
Okay,
Part of the issue was it was announced to the court that there was 15 violations.
okay. But this is the 1024 case that I'm supposed to hear?
Yes.
Okay, okay. Now, he said I may have to get there an hour early? He said I need an hour to fill me in on what's happening?
I'm not exactly.
Yeah, all
I
right,
don't know.
okay.
In fact, I would advise.
Yeah, in his courtroom. Yeah, all right, I'll see y'all then. Thank you, sir. All right, I got Samuel Cradle. This is y'all's, Miss Feely?
It is, and it looks like he's been here before the court.
All right,
Is there no notes in honesty about any violations?
all right, ankle monitor, what you got?
We have no violations for him at the moment.
What about you, Bostic?
No new arrests, been out since 11/23/22.
Mr. Jenkins?
Subject good notice, Your Honor, state's request for bench warrant, bond forfeiture.
All right, I'll email Judge Williams.
Especially with no violation, no new arrests.
All right, let's see, number 15, Tariq Loban. There he is.
Good morning, Your Honor. Teresa Mafud with the Law Offices of Carson R. Matthews.
All right, go ahead, ankle monitor, what you got?
He's in compliance.
Bostic?
He's had 4 arrests since getting out 9/4/22, 9/15/23 for ID theft out of Cherokee, 4/11/24 for battery family violence, 9/23/24 for simple battery family violence, 9/24/24 for violation of family violence or an obstruction out of Gwinnett.
And Your Honor, my understanding is that Gwinnett County case wasn't even prosecuted. They didn't have sufficient evidence to prosecute that. And the others, were they misdemeanors?
All 3.
The others are misdemeanors. Except Cherokee County, it's nonviolent. That was ID
theft?
Yeah.
Okay.
And he hasn't had, since that, since that happened, he hasn't had anything else, but he has been in compliance. He has done everything that has been asked of him on ankle monitor. And he is currently working with Georgia AAU football, and he just got a position as head coach for AAU basketball. For
GFL.
Yeah, what's the age group?
9 and 10.
9 and 10-year-olds.
All right, let's see.
And my understanding is he's been doing an amazing job as a coach.
Did he have modified his bond?
So
has this bond ever been modified?
We had a pending motion at one point to remove the ankle monitor.
Because one of my says, County.
out of Fulton County. I believe that was modified, Your Honor. That was modified. Because I think Attorney Matthews and I handled that a while ago because it wasn't possible, I think, based on his job.
I'm looking forward to see this. Motion to modify, but I don't see what's been modified. Yeah, I see a motion modified. It was filed in March, but just don't see where it's been modified. Mr. Jenkins?
Well, I mean, there's a distinction between a motion to modify and a modification order granted by the court. And so we certainly don't have a problem with him in the AAU, but that puts him in Fulton County. Well, that's a problem.
Let's see. So that's work, or is that like volunteer stuff?
It's volunteer.
But it's work?
Yeah, it's work.
Okay. There.
And it's in Gwinnett County.
Did you let the ankle monitoring company know about that?
Yeah, all the time.
Okay, because it says you'll set up Fulton County except for work.
I don't work here. The job is
Yeah.
in Gwinnett.
Oh, yeah, the AAU is in Gwinnett County, Your Honor.
Okay, yeah, this is out of Fulton, well, it says work or court. Is there any other reason you need to be out of Fulton, in Fulton County?
Doctor. And then I had called one time and told him I had to pick my son up. He's at his grandmother's house. My wife is at the
Okay.
house.
All right, if that needs to be modified, or something, let me know when you talk to Mr. Matthews,
Yes.
okay?
Yes, Your Honor. Should we, I know he's tried to change it. I thought that it was changed. Should we just file or
Yeah, you can
submit
file
an
it, send
order?
it to Mr. Jenkins, see if he, yeah, send it to him. So, but all those other violations, I mean. So, got it? Keep it charged, do what you're supposed to do. Thank you. Have a good one.
Thank you, Your Honor.
Thank you. All right, Daniel.
Business, may I be excused?
Yes, ma'am. Daniel Pagan.
You have a card, I can write my email address for you.
Daniel Pagan.
No.
So Daniel Pagan. Bostic, what do you got? Anything?
Pagan, got out 8/8/22, has 4 arrests since then. Last one was for driving with suspended license, 8/23/23. He was in Fulton County
All right.
for a day for that. And in on a FTA at 8/23/23 also.
What about you, Anchorman?
He's not interested. He got on 8/8/22. From another company before us.
Okay. Well, I don't know how we kind of check on that, but somehow we'll figure it out. All right, thank you. What about, now this one's in jail. Jeanette Tellis Iceless.
She's been sentenced. She was sentenced.
When was she sentenced?
10/2/25.
When was she sentenced? Because
10/2.
Pagan, he's not here.
2 years incarcerated, 8 years confinement,
I took first for no.
8 years probation, I mean.
All right. So she's been,
What position are we on?
17, was sentenced 10/2.
She's already sentenced in this case?
Yes.
Mhm.
All right.
Yes.
Well, that absolves this.
All right.
Did I request a bond forfeiture on 16?
Yes.
Okay.
So we'll check and see. I'll speak with Judge Kraus and see what.
Yes, Your Honor.
Yeah. I don't know what's happening when they're not turning them over. Sydney Stinchcomb. So if she can go back. Sydney Stinchcomb. Bostic,
No new arrests, been out since 4/2/23.
ankle monitor.
She has a stay away order to stay away from Joseph Lowry Boulevard Road, and she's been there for 4 times.
Ms. Feely.
Given the nature of the charge and the fact that this is assigned to Judge Cox, we've just asked that she be allowed to continue addressing her matter with Judge Cox.
Judge, in a case like this, with this type of charge, I'll leave it in the court's discretion.
All right. It looks like it looks like she may be in judicial hold anyway.
Hey, I don't know what's going on here, but.
All right. I'll check with Judge Cox and
Okay.
let
Yes.
you know. All right. What about John Shawcross? John Shawcross. John Shawcross. Bostic,
No new arrests, been out since 9/8/22.
ankle monitor.
Not tracking.
Since when?
Since we took over the company in 4/24/24.
Might be in prison somewhere. Who knows?
Hold on, what now?
Probably sent an email saying.
Is he in DeKalb now?
He's been investigated to get counseling and now in the drug courtroom.
So he's not in custody anymore.
And appeared in court for judges on October 14th.
All right, I'll check with Judge Williams.
All right. So it was in court on the 14th? Yeah, that would be,
Okay,
before we issue a bench warrant.
all right. Ahmed Salih. Ahmed Salih. Come on up, sir. All right. What do we got?
Got out 7/9/22 arrests for a firearm that was dismissed, and he got out 4/5/24.
All right, ankle monitor.
He's only had one violation at a residential home that's not his stay on his home zone.
When was that?
37 Amal Drive, Southwest Atlanta, Georgia, 30315.
And I got this, that on 10/10, you were at home for that alert. Talking to you?
Excuse me?
Oh, you're not paying attention.
Oh,
Said I'm
shit.
talking to you. They emailed me and told me that you had not an alert, but you were at home on that one, right?
What was the address again?
No, on 10/10.
1010.
That's not an address, that's a date. On the 10th of October, there was an alert, but they said Barwick said it's already been taken care of, that you were at home when that alert came in, that you were.
Oh, about my ankle monitor?
Right.
Yeah.
That's why we're here.
Yeah, I'm sorry.
All right.
I thought we were sorry.
All right. Thank you so much. I appreciate it. Thank you.
I'm sorry. All right, thank you.
All right. Starrett Boynton. Starrett. Bostic.
No new arrests, 3/15/24.
All right. Ankle monitor.
It shows he has a backplate tamper. That means he would just have to kind of inspect his device and he should be fine.
Wait, say it one more time.
Like he has a backplate tamper, which means he might have hit his ankle monitor on something. We just need to inspect it, make sure it's still on his ankle, and we should be good to go.
So you just need somebody to look at it, or where somebody's going to look at it?
I can do it.
Okay, and just hang out for a second. We're almost done. All right, thank you. All right, let's see. Jemiah Sullivan. Jemiah Sullivan. Bostic.
Sullivan, no new arrests, 2/24/25.
Ankle monitor.
We don't have anything on her.
All right, Mr. Showalter. Looks like you've got a motion in here anyway, right?
Yeah, I do have a pending motion to remove the ankle monitor and modify bond conditions if the court would consider that this time.
She's still living in that location, or
Yeah.
Mr. Jenkins? I don't know if you got it pulled up.
We certainly would, given that there's two capital offenses charged here in this matter. And when was this person placed on the ankle monitor? It's pre-indictment, so it's fairly recent.
It was February 24th.
All right. With those offenses, we certainly object to the removal of an ankle monitor.
So it's got, it also asked for modify the 24-hour curfew. So what does she need it?
Yeah,
No,
I
but put it
want-
on the record what she needs it modified.
Okay, so if the conditions are difficult for her to maintain because she's really doing like hotel living, and she doesn't have much of a criminal history at all. And so I'll be asking the court, this is her second time in front of you regarding the compliance hearings, and she's been found to be compliant both times. And since she's had this thing on since the 24th, she's been doing the best she can with it. Anytime she has to go anywhere, she is calling up the ankle monitor company.
Is she able to work?
She is able to work, but you know, things are tough.
I mean, is the ankle monitor hindering her ability to work? I guess that's what I'm looking at for the 24-hour curfew.
I mean, would you say so?
I mean, Spicy did die at work. I know that.
Yeah.
But other than that, you know.
All right.
Because it says with exceptions of work, legal, medical emergency, or I didn't do this as appointment, which I don't know what that means. So if you want to send it to Mr. Jenkins, and because I don't know when you'll be back on the calendar for the, is this on the, yeah, well, 10/21. No, that's, looks like it's back on 10/21. Yeah, it looks like you're on for 10/21 at 9 a.m. to be. We'll let them talk about that, okay?
All right.
All right, thank you, ma'am.
Do that.
All right, I got, this one's in jail, Power Sebron.
Yeah, been in custody 8/5/25 for an FTA on another case, 24 SC 004345, an ag assault firearm by.
Go ahead.
Hold on, he's been in jail since 8/5/25. I think we were here for that.
You want to bring him out?
Yes.
Yeah. What was that case number 24?
24 SC 004345.
So on these charges, it looks like he got out in February.
Initially 1/24/25 on this case.
I hate to make you do it again, Bostic, but preach.
He's been in custody since 8/5/25 on the open case, 24 SC 004345, ag assault firearm during firearm by. He got it out on this case 1/24/25.
All right, and ankle monitor.
We took off the ankle monitor the last time we were here for his,
For him to go to jail?
mhm.
Okay. Let me see, let me go up to the other case. 24. Mr. Jenkins. Yes.
He doesn't have an ankle monitor on. I mean, he's in custody.
Yeah.
So, I mean, is there a formal removal order from the court?
Okay. So you were set for trial on, wait, is it still, you were set for trial for this one, right? On October 14th? How you doing?
Oh, how you doing, Judge?
You were
Manning?
set for trial, right? October 14th?
Yes, ma'am.
All right. All right, I'll reach out to Judge Dunaway. All right, let me see what Judge Dunaway wants. When you get out there, you're gonna have to report, okay? And tell them that, you need to put an ankle monitor back on.
All right, no problem.
Ms. Feely?
This is his mother, but unfortunately, it looks to me like he's in jail on the 34 SC case with Judge Dunaway, so that the court wouldn't be able to
Right,
do anything to release him at this point.
that's it.
That particular case.
Thank you. Thank you, sir.
Am I gonna be able to get released?
Well, I'm gonna talk to Judge Dunaway. All right, Janisha Crumbly. Come on up, Ms. Crumbly. Go ahead.
No new arrests, had it on 6/22/25.
Ankle monitor.
We don't have anything on her. The only thing is she lives really close to her stay away zone, about 300 feet away from it. So we have a lot of GPS drift.
He speaks too fast for me to
sorry.
understand.
Yeah, okay, hold on.
We have no violations
Hold on,
for her.
hold on one second. Hey, tell to the. All right, go ahead, one more time.
We have no violations for her at this moment, but she lives about 300 feet from her stay away zone. So we have a lot of GPS drifts, which is not violation, no violations.
Okay.
Go ahead.
All right. I mean, it sounds like there's no violations. And if I understand, he's just saying that she happens to live close to the stay away location. And so they can't really be calling it violations.
Guess you gotta be careful and tiptoe around there, because you know where you're supposed to stay away from, right?
Yes, ma'am.
All right, outstanding. Thank you, ma'am. Have a good day. Ethan. All right, on the add-on calendar, we got,
Add-on?
yeah. Oh, no.
Let me see.
Hold on.
Oh, here it is.
Didn't have it.
No.
Right.
Anybody got an extra?
Bostic didn't have it. You got an extra one?
Probably gonna have the histories on it, but
I don't know. All right, I got, is it Ania Shavers? Come on up, ma'am. Come on up to the podium. Where's, there he is. Oh, here's Mr. Ribson. He had to. Hey, I got him. Yeah, he's on here. Hold on one second. Let him get in here. Mr. Remsen.
you know.
Hey, Your Honor.
Hey, how are you? All right, go ahead. Bostic, you have anything? Or let me take the ankle monitor first.
History's not in there. She got out 7/26/25.
All right, ankle monitor company. Anything?
I don't have anything on her, but let me confirm on my end over here.
Do you understand him? Mr. Remsen, did you understand him?
Yes, thank you, Judge.
All right, hold on one sec.
No, man, we don't have anything for her.
All right, outstanding. Good job. Just keep it charged, okay? Thank you, ma'am. All right,
Perfect,
thank you,
thank
Mr. Benson.
Thank
Have a
you,
good
Your
day.
Honor.
Have a good day. All right, I got Cordero Brewster, number 2, Cordero Brewster. Bostic, you don't have anything on him either. So what about ankle monitor?
He just got out 7/2/25 after spending 736 days in custody.
I think he has final plea in front of Judge Leffridge on 24. Is this yours, Miss Feely?
Let's see.
Position 2 on the add-on?
Yeah, number 2 on that, on the add-on.
This is the one that is with Judge Leffridge. It is one of ours. There were any notes and obviously about any violations.
No new arrest, Judge.
Okay. Judge. Yeah, I saw that. All right, I'll let, all right. What says the state, Mr. Jenkins?
How long has it been out?
7/2.
And it was placed with an ankle monitor as upon his release?
Yeah.
That's a bench warrant bond forfeiture.
All right. All right, about Daniel Gabriel. Outstanding.
And on number 2, I didn't hear if there were any ankle monitor violations. Did I miss that part?
No, he doesn't. We don't have anything on him.
You don't, they don't have, you don't have anything on him? What does that mean?
He has no violations. He's in compliance.
Well, where's he at right now? Can you see? Because he's not at 136 prior.
He's at 1317 Sharon Street, Atlanta, Georgia. From 10:07 a.m.
Interpreter on this one? All right, you swear affirm you'll translate from English to Spanish, Spanish to English, to the best of your knowledge, skills, and abilities.
Yes.
All right.
No new arrests. Let me see when he got out. Just a second.
I assume this is Daddy Baby.
Got out 7/29/25.
All right. Ankle monitor.
Daniel Gabriel. He has no violations in compliance at this moment.
Él ha estado cumpliendo con las reglas del grillete electrónico, no ha quebrado ninguna regla del grillete electrónico.
All right, thank you. Ms. Feely, you want anything other than
¿Algo más?
have a good day, right? All right. Thank you, sir. Have a good day. Just keep it charged. If you go anywhere and have to do something, make sure you notify the ankle monitor company.
Gracias, señor. Usted está cumpliendo. Si usted tiene que salir o tiene que moverse, por favor, mantenga a la compañía del grillete electrónico al tanto de su paradero. También asegúrese de mantener su grillete electrónico cargado. Tengo una pregunta. I have a question.
Oh, my goodness. Okay.
No, no hay ningún problema que yo me vaya a otro estado por asuntos como de, no sé, algún, como por ejemplo, si tengo que ir a visitar a mi familia por un día o algo así. So I'm wondering if there would be any issue if I were to leave the state, like perhaps if I were to visit a relative out of state for perhaps a day, would there be any issue with that?
Let's see.
Vamos a ver.
So since Ms. Feely doesn't have it, I will tell you. I'll put this.
Pili no tiene ahí, déjeme ver su expediente.
So looks like your bond conditions are stay away from 1620 Hollywood Road.
Parece ser que la condición de su fianza es de que usted se mantenga alejado del 1620 Hollywood Road
No weapons, no alcohol,
y de que no tendrá armas ni alcohol
no drugs without a legal prescription,
y de que no tendrá drogas sin que se les sean recetadas legalmente
and no further contact with Jennifer Lopez.
y de que no tendrá contacto con Jennifer López.
So that'll help Ms. Feely answer your question, okay?
No sé si eso le ayudará a la señora Pili a responder su pregunta.
Is there anything he needs to do for the ankle monitor company?
Algo que tiene que
I
ser
understand he
por
doesn't have a
parte
bond
de la
condition.
compañía.
not
Yeah.
prohibiting him.
I would say let them know. Now, what do you feel about him going out of state?
Díganle, ¿cómo se siente si es que él sale fuera del estado? Le pregunta.
I apologize, Your Honor.
That's okay.
Take a motion.
Disculpa.
I mean, he doesn't have any conditions to like stay in it. He didn't have a 24-hour or anything like that. What do you say about him like going out of state to see a relative?
I don't have an objection as long as there is notice given to pretrial and the ankle monitor company and the court itself, establishing where he will be located and his time of return.
Okay.
La expectativa de que él regresará al estado.
You good? All right.
¿Le parece bien? Sí.
I got this.
Thank you.
Gracias.
Thank you. The interpreter be excused.
Yes, didn't you sign your piece of paper?
Yes.
All right, you can bring it up. What about,
Get the name of the interpreter?
excuse me, can you go ahead and say and spell your name for the,
Juan Bernal, Juanbernal.
Thank you.
all right, let's see, I've got Deontay Bryant. Thank you, sir. All right, free trial.
No new arrests, got out 7/11/25.
All right, ankle monitor.
He's been in compliance.
All right. Let's see, unindicted yet. Well, it's good to see you though, Mr. Hines.
Good to see you
All
also.
right, thank you, sir. Just make sure if there's anything that you need, you make sure you call the ankle monitoring company and your lawyer, okay?
Okay.
All right, thank you, sir.
Thank you, Your Honor. May we be excused?
Yes, sir. Have a good week. All right, I got Kendrell Knox. Kendrell Knox. So I'll tell you that with this one, it's kind of been back and forth where he's changed his address and that's where Mr. Mohammed says, oh, well, it's in Odyssey. And let's see, it's Judge Schwall. So I'll ask Judge Schwall, it's supposed to have a November trial date. Let's see. I can't really tell when this one. Okay. So I don't know where Mr. Muhammad is. Bostic, anything?
He got out 6/23/24, 2 arrests since then, an open case now for a controlled substance and driving with a suspended license, and was arrested also on an FTA on a battery 6/21/25, got out 7/15/25.
Ankle monitor.
The only thing we have on him is low batteries, but they're not really dead. It's really, really low.
Okay, low batteries, but it's,
Still tracking. It's like 2%, 3% on the batteries. You should just call him and make sure he's charging his device.
so where's he at now?
He is at
Besides not at 136 prior.
128 Shadow Creek, Fairburn, Georgia.
Let's see.
Was a hearing notice about the person, the person who secured the bond, so that was not them. It didn't come with that only.
Where was the other one sent? No, what address? Was it sent to the address he just called out, or was it sent to the address there? You sent one to who was on his bond also? Because in Odyssey, it says Lake Royal Drive. Is that the address you have for him?
The address I have from is 849 Wagon Wheel Circle.
I have Lake Royal Drive in this room.
Did the notice sent to him come back?
No, the notice is him now.
Okay. Mr. Jenkins.
Thank you, Judge. At this time, subject to good notice, being checked. If it wasn't his court, state request bench warrant powerful.
All right.
Unfortunately,
Thank you.
been trafficking.
Judge,
Yeah.
going back to, what's his name, Shaw Cross? It shows that he got out for a violation 11-124 in the cab system. That he's not still in there by their system. He was in there for violation of drug court, but he's not in there now.
For Shellcross, that's, what number is that again?
Number 19.
So he's not in there.
No, he was booked in 10-31-24, got out 11-124.
So Miss Feely, he's not in DeKalb County, Mr. Shellcross. Ma'am, you sit. Miss Feely. Now, so number 19, he's not in DeKalb County. Pretrial said he got out.
He did have court, looks like, with Judge Williams last week. Given that he has no new arrests, and it sounded like he was in the DeKalb County drug court program. It would be relatively easy to track down, but if he was, we would just ask the court to allow Judge Williams to continue dealing with it. And position 19, I think, also has a private attorney.
Oh, she's not with y'all anymore?
She did not, I mean, I'm happy to at least advocate for him not to get a bench warrant.
That's all right. So what I'll do is I'll talk with Judge Williams too, see if he showed up. If not, because I don't see where anything's been returned. All right?
Oh, good, Judge.
Anything else? Adios, you can leave.
Sorry.
Oh, okay.
Mr. Daniel would like Madam Feely's phone number.
Oh,
You can contact her if he's going out of town.
well, I don't think she's his,
Or the public defender's phone number.
oh, okay. Because I don't think she's his lawyer.
Oh,
It's somebody else, but she's here for the public defender's office.
right.
Yeah. All right, anything from anybody else? Outstanding job, Madam Court Reporter.
Thank you so much, ma'am. And the only thing I need is just the second chance representative's first and last name.
All right.
First name is Anderson, Anderson. Last name is Kamau, Kamau.
All right, that's all.
Thank you, ma'am.
Thank you. Have a great
good one.
day.
You too.
Judge,
Yo,
is there 1:30 calendar?
no.
It's on.
So that'll be it for today. Tomorrow's going to be Mr. Magoo. I see Mr. Magoo has been called back to Judge Simpson's court. So we'll see if Mr. Magoo pisses off Judge Simpson. So that's it for today. If you're not a subscriber to this channel and you like this content, please do me a big favor and subscribe to this channel and help this channel grow. I really appreciate the new subscribers to this channel. I really do. I appreciate everybody that's on here. And you helping me to work harder So you all have a wonderful evening. Ta-ta and ciao ciao. I will see you guys tomorrow.